Well, Stephen, thanks very much, sir, for coming on the program tonight.
Thanks for having me, Cam.
My pleasure. And tonight, unfortunately, we're going to talk about a situation that happens every so often. A gun owner gets divorced, and this is a time emotions are running high, Stephen, and bad things can happen.
Well, bad things can happen, and people start using all sorts of tricks that they think can get them an advantage in the litigation. They start making all sorts of accusations. Sometimes the accusations are true, but unfortunately, many times the accusations are not, or they're exaggerated. And more and more child custody cases, especially. I mean, that's when the emotions really run high. More and more child custody cases are coming to our attention here in the General Counsel's office. And you may ask yourself, well, what does a child custody case have to do with the Second Amendment, the right to keep and bear arms, firearms? Well, Cam, here's what's happening. Some divorcing spouses and their attorneys are arguing, and the unfortunate thing is that some judges are buying the argument. What they're arguing is that the other spouse should not be entitled to have custody rights because the other spouse owns firearms. Now, if you think about that, their argument is basically that because you are exercising constitutional right, namely, your right to keep and bear arms, your Second Amendment rights, their argument is that you should be discriminated against and that you should not be allowed to have custody rights in regard to your own children, all because you're doing something that's perfectly legal. In fact, that's constitutionally protected. And here's the thing to keep in mind, Cam. These cases that I'm talking about, they do not involve any allegation of wrongdoing. These cases stand for the proposition, the argument, that simply because you lawfully possess a firearm, and again, Cam, this is the lawful exercise of a constitutional right,
Yeah.
that simply because you lawfully possess a firearm that you should be discriminated against and that you should not be allowed to have custody over your children. And, that is outrageous, okay?
Absolutely.
And we're going to talk about one such case today, and that case went all the way to the state court of appeals, and the case is a Tennessee case called Stillwell. Now, Dr. Thomas Stillwell was a practicing dentist in Tennessee at the time. And unfortunately, Dr. Stillwell and his wife were getting a divorce, and more and more people. I mean, now what it is now, more than half the folks in this country getting married get divorced.
I think so. Yeah.
So very common occurrence nowadays. But initially things went smoothly. The husband and the wife, they got together, they worked out and agreed on the property division, on custody issues. And then they actually executed a marital dissolution agreement, which divided the marital estate, the property, and provided for the care and custody of their minor son. And what they agreed to was to share joint custody of the child. The mother got primary physical custody of the child, and Dr. Stillwell, he got certain visitation rights, and he also got custody of the son every other weekend and on certain holidays, okay? The divorce was then finalized through the courts, and the court entered a final decree of divorce, which incorporated the marital dissolution agreement into its final decree. So bottom line, the custody agreement that I mentioned a moment ago that the parents agreed to became part of the court's divorce decree, okay? But about 6 months after the final decree was entered, the ex-wife now suddenly files a petition to modify the decree, okay? And remember, in divorce proceedings, when it comes to child custody and child support issues, those can be modified. They're never really final, okay?
Mm-hmm.
Well, the ex-wife claimed, among other things, that Dr. Stillwell was a diabetic and that he also owned firearms. And, in fact, he had a carry permit for a handgun, and that because of these facts, she was fearful of the child's safety. And the ex-wife requested that the court impose restrictions on Dr. Stillwell's possession of firearms when the child was with him. Specifically, she requested that the court prohibit Dr. Stillwell from possessing firearms when the child was in his custody. Now, Cam, again, I got to mention, there was no allegation made that Dr. Stillwell mishandled firearms, that he used them unlawfully, that he threatened anyone, that he did anything that was negligent.
Right.
There was none of that. None of that. There wasn't even an allegation. There was not even an allegation that he left guns lying around when the child was visiting. And in fact, Cam, Dr. Stillwell kept all but one of his guns, his carry gun.
Yeah.
He kept all the other ones securely locked up at all times. And when his son visited him, and when he had custody, he even stored his carry gun, locked it and stored it, okay?
Okay.
So there was no way the child could get at it. But despite all these facts, the court concluded that there was a legitimate safety issue in light of Dr. Stillwell's diabetes, and the trial court ordered, quote, that there shall be no guns of any sort around the child while he is visiting with Dr. Stillwell, and that any guns in his home when the child's there shall be locked up and kept out of his control, unquote. Well, Dr. Stillwell did the right thing. He appealed. He was first he was totally appalled by this totally unwarranted assault on his constitutionally protected civil rights.
Sure.
And at this blatant and totally unwarranted discrimination against him because of his diabetes. Remember, the judge and the ex-wife complained about not just him possessing firearms, but also suggested that because of his diabetes, he's even more dangerous. So he was totally appalled by that. So he appealed the trial court's ruling to the Court of Appeals of Tennessee. Now, even before this, Cam, it's been established as a matter of constitutional law, U.S. Supreme Court law, constitutional law, that a parent has a right to rear his or her children without the interference of the state. And this has been recognized as a fundamental, constitutionally protected liberty interest protected by the 14th Amendment, and has also been recognized as a fundamental right derived from the privacy rights inherent in the Constitution. So when they get to the Court of Appeals, Dr. Stillwell argued, amongst other things, that the trial court's prohibition on him carrying a firearm in the presence of the child and ordering that all guns be locked up, that in addition to what I just mentioned, the right to rear your own children without the state's interference, that this also violated his right to bear arms under both the Second Amendment of the U.S. Constitution as well as Article 1, Section 26 of the Tennessee Constitution. And Article 1, Section 26, that's the right to keep and bear arms under the state constitution in Tennessee. Now, the Court of Appeals of Tennessee noted that there was no evidence of misbehavior on Dr. Stillwell's part. Again, no allegation that he mishandled firearms, that he left them lying around, that he threatened anyone, or that he did anything negligent, okay? The Court of Appeals noted that. And then the Court of Appeals cited a prior decision by the Supreme Court of Tennessee. And that was also, comparatively speaking, a recent case, the 1993 Tennessee Supreme Court case of Hawk v. Hawk. And in that case, in the Hawk case, the Tennessee Supreme Court had held, quote, that when no substantial harm threatens a child's welfare, the state lacks a sufficiently compelling justification for the infringement on the fundamental right of parents to raise their children as they see fit, unquote. And the Tennessee Supreme Court held that absent a substantial danger of harm to a child, quote, a court may not constitutionally impose its own subjective notions of the best interest of the child, unquote. So, citing this Tennessee Supreme Court case from 1993, the Court of Appeals in Tennessee, in the Stillwell case, concluded that Dr. Stillwell's parental constitutional rights of privacy had been violated by the trial court's order. Okay, so that deals with the first issue. And the second issue, in regards to the second issue, namely the right to keep and bear arms issue, the Court of Appeals of Tennessee stated, quote, we believe the constitutional rights under the Second Amendment of the United States Constitution, as well as Article 1, Section 26 of the Tennessee Constitution, are worthy of the same protection as is the constitutional right to privacy, unquote. And remember, Cam, it's my own little commentary here, the right to privacy, that's not explicitly stated in the Constitution.
Right.
Whereas, when it comes to the right to keep and bear arms, you've got explicit written guarantee that right shall not be infringed in the Constitution. And the Court of Appeals then concluded that the trial court could not restrict Dr. Stillwell's otherwise lawful possession of a firearm absent a showing of risk of substantial harm to the child. And here's what the Court of Appeals said, quote, while the trial court did find that the mother's concerns regarding the child and the guns was a legitimate safety issue and concern, such a finding is not a finding of risk of substantial harm to the child. So basically what they're saying is, yeah, you can say this is a concern and an issue, but saying it's a concern and issue is not the same thing as finding that there actually was a risk, And again, there was no evidence of Dr. Stillwell having done anything bad or anything negligent, always kept the guns locked up, all of that stuff. And the Court of Appeals added that the fact that Dr. Stillwell had diabetes, that fact was insufficient to conclude that Dr. Stillwell's possession of a firearm placed the child at risk of substantial harm. Now, regarding the trial court's bias against Dr. Stillwell's decision to exercise a constitutionally protected right, namely his decision to own, firearms, the Court of Appeals stated this, quote, absent a risk of substantial harm to the child, The wisdom of Dr. Stillwell's decision is not for the trial court or this court to determine, unquote. Now, Cam, this is a case where Dr. Stillwell's attorney did the right thing, okay? He contacted us, the NRA Civil Rights Defense Fund, the General Counsel's Office here, and then he applied for and got funding from the NRA Civil Rights Defense Fund, and in the end effect, everything turned out well, okay? But what you got to realize is there are many such domestic relations and divorce cases out there where, spouses are arguing that the other spouse should be discriminated against because the other spouse lawfully owns or possesses a gun or hunts. And you have many of these cases where courts are issuing orders prohibiting a parent from merely possessing a firearm in the house when the child's with them, or possessing a firearm at all, or prohibiting a parent from taking the child hunting or target shooting. And these divorce cases, there's a lot of emotions going on. There's a lot of people are trying to rearrange their lives in the aftermath of a divorce, and the cost and expense are high, and a lot of times, the spouse that is being hit with such a motion and such an order doesn't bother appealing or fighting this, okay?
Mm-hmm.
Let me tell you about one case, a Massachusetts divorce case. This one, the NRA wasn't involved in, where a woman filed 26 criminal cases in 3 courts alleging that the father was violent, okay? 26 criminal cases she files, okay, in 3 different courts. The woman then underwent psychological tests that conclude that she was experiencing numerous psychological episodes and problems, okay? And that the father was not violent, okay? However, the judge still issued a permanent restraining order against the father, ordering him to surrender all his guns and ammunition, okay? Well, maybe that's just Massachusetts for you. But, in our case, the one I was talking about today, the Stillwell case, the Tennessee case, well, that one, everything came out well because the father was willing to fight for his rights, and because the attorney, Dr. Stillwell's attorney, appealed to the NRA Civil Rights Defense Fund to help fund the case, and we helped fund the case, and they appealed the trial court's ruling to the Tennessee Court of Appeals, and now we have a recorded decision of the Court of Appeals in Tennessee, binding law in Tennessee, and that's all good. But, again, there's so many other cases out there where the spouse, being caught up in the middle of an ugly divorce and expensive court proceedings, just doesn't have the time, the energy, or the money to fight these types of unconstitutional discriminatory restrictions. They may be fighting over the sale of the house and who has the right to the pension, and the order dealing with the father having to give up his firearms. Maybe that's the least of the gentleman's worry at the time. So everything went well in this case, but believe me, there's plenty of other ones out there where this stuff is going on, and where folks don't avail themselves of their rights because they've got other things to worry about. And
unfortunately, you're right, Stephen. But again, if folks want an attorney referral list, they can go to NRADefenseFund.org, and they can get the list of attorneys in their area who want to work on Second Amendment issues, right?
Right. The General Counsel's Office has an attorney referral list, so we can do exactly what you just said, refer them to an attorney who wants to work on these kinds of cases, and secondarily, the NRA Civil Rights Defense Fund provides funding for these types of cases. Now, of course, you have to file an application, and the Board of Trustees of the Civil Rights Defense Fund meets 3 times a year in conjunction with the NRA board meetings, at which the cases that are presented to them are reviewed, and the Board of Trustees then makes a decision as to whether or not to fund that case.
All right, Stephen, thank you again, sir, for coming on the program, and look forward to doing it again next week.
Always my pleasure.
Stephen Thomas, Deputy General Counsel of the National Rifle Association, joining us here on Cam &